Hello and welcome to Law Kanya. In this series, we will study the important judgments that has been given by Justice R.F.Nariman, former Supreme Court judge. He was appointed as a judge of the Supreme Court on July 7, 2014. He was only the fifth senior counsel to be elevated from the bar to the bench. Justice Nariman's 7 years old tenure as a judge of the Supreme Court has come to an end on August 12. During his tenure, Justice Nariman has authored notable judgments that have contributed to country's evolving jurisprudence on fundamental rights and liberties of citizens. Justice Nariman was also part of the bench which steered the controversial NRC process in Assam and operationalization foreigners tribunal there, which resulted in casting a shadow on the citizenship of millions of Assam inhabitants, and then the detention of many of them as being adjudged as illegal migrants. He was also part of the bench which passed the order in controversial suo motu to probe the alleged larger conspiracy behind the sexual harassment allegations against CGI Ranjan Gogoi. Here is a list of some notable judgments of Justice Nariman. So, let's begin. The first judgment is in 2004, where Justice Nariman authored for the majority of the Constitution bench that had delivered the landmark decision of Muhammad ARIF versus the Registrar Supreme Court. This case held that the open court hearing was mandatory in review petitions against death sentences, and that they should be heard by a bench of at least 3 judges. When it is a question of life and death of a person, even a remote chance of deviating from such a decision while exercising the review jurisdiction would justify oral hearing in review petition, Justice Nariman had observed. Moving further, in 2015, in the famous case of SHREYA SINGHAL versus Union of India, which declared Section 66A of the Information Technology Act 2000 to be unconstitutional and in violation of Article 19, Clause 1, Subclause A of the Constitution. The judgment had stated that several terms in the provisions were open-ended, undefined and vague, which made them nebulous in nature. And to this, Justice Nariman had noted that it is clear that Section 66A arbitrarily, excessively and disproportionately invades the right of free speech and upsets the balance between such right and reasonable restrictions that may be imposed on such rights. Further, he was also part of the 9-judge Constitution bench which had delivered the historic judgment in Justice K.S. PUTTASWAMY versus Union of India in 2017, which unanimously recognized that right to privacy is a fundamental right guaranteed under Article 21 of the Constitution, and this case has subsequently overruled the decisions in MPs Sharma and Khadak Singh's case. To note, the preamble of the Constitution, which can be said to reflect core constitutional values, the core value of the nation being democratic, would be hollow unless persons in a democracy are able to develop fully in order to make informed choices for themselves, which affect their daily lives and the daily choices of how they are to be governed, Justice Nariman had observed. Further, in 2017 itself, he was part of the 5-judge bench which struck down Section 497 of the Indian Penal Code, thereby decriminalizing adultery. In this case of Joseph Shine versus Union of India, which declared Section 497 of the IPC and Section 198 of the Code of Criminal Procedure to be in violation of Article 14, 15, Clause 1 and Article 21 of the Constitution, opining that such criminalization of adultery regrets the agency and status of a woman, Justice Nariman had observed that the real hurt of this anarchic law discloses itself when consent or connivance of the married woman's husband is obtained. The married or unmarried man who has sexual intercourse with such a woman does not then commit the offense of adultery. This can only be on the parentalistic notion of a woman being linked to a chattel. For if one is used to the chattel or is licensed to use the chattel by the licensor, namely the husband, no offense is committed. Consequently, the wife who has committed adultery is not the subject matter of the offence and cannot, for the reason she is regarded only as chattel, even if punished as an abettor. This is also for the chivalristic reason that third party male seducer her, she being his victim. What is clear, therefore, is that this archaic law has long outlived its purpose and does not square with today's constitutional morality, in that the very object which is was made and since become manifestly arbitrary, having lost its rationale long ago, and having become in today's age and utterly irrational. See how beautifully Justice Nariman had quoted the whole thing and made it in so simple and easy languages. Now, the next case is of Sabarimala, where the bench by 4:1 majority had held that the temple's practice of barring the entry of women is unconstitutional and of violative of Article 25, Clause 1 of the Constitution. This was in the case of Young Indian Lawyers Association versus State of Kerala. He had observed that majority of a religious group cannot violate the right of worship of an individual believer on the ground of simply gender. Yet another in the case of SHREYA BANO versus Union of India, where the court by 3:2 majority had held that the practice of instant triple talaq, or better known as the talaq-e-biddat, is unconstitutional and violative of Article 14 and 15 of the Constitution. Justice Nariman, along with Justice U. Lalit, had authored the majority judgment, which observed that the practice of the triple talaq, as regulated by the Shariat Act, is unconstitutional because it is manifestly arbitrary in nature. He had observed that a provision of law would be manifestly arbitrary if it lacked a clear detrimentive principle or encapsulated a spurious or irrational measure. Agreeing with the majority, he had held, given the fact that triple talaq is instant and irrevocable, it is obvious that any attempt at reconciliation between the husband and the wife by two arbitrators from their families, which is essential to save the marital tie, cannot ever take place. Next is yet another important judgment which grants equal protection to the members of the LGBTQI+ community. Justice Nariman, in the landmark decision of NAVTEJ Singh JOHAR versus Union of India, had partially struck down Section 377 of the Indian Penal Code, which made carnal intercourse against the order of nature a criminal offence. He had opined that rationale behind Section 377 was to impose a Victorian sense of morality, which has long gone now. Notably, he imposed an obligation on the Union of India to take all measures to publicize the judgment so as to eliminate the stigma faced by the LGBT community in society. He also directed that the government and police officials be sensitive to the plight of this particular community so as to ensure favorable treatment for them. Now, next case is of Hindustan Construction Company versus Union of India, where Justice Nariman, along with other judges in the case, had struck down Section 87 of the Arbitration and Conciliation Act, which was inserted through 2019 amendment. It was opined that provision which allowed for an automatic stay on enforcement of awards is manifestly arbitrary and violative of Article 14. The provision sought to nullify the effect of 2018 judgment of Justice Nariman in BCCI versus Kochi Cricket Private Limited's case, which decided the prospective application of automatic stay provisions in the Act. During the hearing, Justice Nariman had remarked that 2019 amendment was a retrograde step which will prevent India from becoming a hub of international arbitrations. Now, this one is very important. This relates to installation of CCTV cameras at every police station, which directed in 2020 that all the state and the union governments must ensure that a CCTV camera is installed in each and every police station functioning under them. The central government had also been ordered to install the cameras and recording equipments in the offices of central agencies like the CBI, NIA, etc., opining that these directions were in furtherance of the fundamental right guaranteed under Article 21 of the Constitution. The bench led by Justice Nariman had set up a district 6 weeks timeline to ensure its compliance. Now, the next case was given in 2019, which ruled that a magistrate can invoke powers conferred under Section 156, Clause 3 of the Code of the Criminal Procedure in order to further investigate into an offence even after the post-cognizance case stage, and accordingly proceeded to overrule a 43-year-old precedent. Now, the Gujarat High Court in the judgment of Devarapalli Lakshmanaraya Reddy versus Narayan Reddy. Now, 3 bench in this case has observed that the impugned judgment had failed to take into consideration the definition of investigation given under Section 2 of the CRPC. You might want to look into the barracks for these particular sections, Section 156 Clause 3 and Section 2H of the investigation, and look out how beautifully court had done this. So, this was some of the important judgments given by Justice R. Nariman. You might look into other cases as well. If you like such contents, do subscribe to my channel and do share this. Thank you for watching.